Hi everyone, welcome to my channel. And in this video, let us discuss the nature and sources of law. First, let's see the meaning of jurisprudence. So, jurisprudence is nothing but it's the study of law. Okay, and juris means judge, and prudence means wisdom. And wisdom of a judge applying a law as well as interpreting it is nothing but jurisprudence as a whole. And now let's see the definition of jurisprudence. So, according to Jeremy Bentham, he says that law is a command of sovereign. And Sir John Salmon he says that common law is nothing but it is a judgment law and case law is gold in the mine and statute law is the coin of the state. And Sir John Salmon he also has divided the law into that is so source of law into two categories which is formal sources and material sources. So first formal sources is nothing but it is the authoritative sources. So which is defined directly from the legislation judicial precedents. And next is material sources are nothing but which is the secondary sources which have been derived from the uh, material it has been derived. So it is like customs, principles of natural justice, and expert opinions. And next jurist is Carl N. Levlin. He has propounded jurisprudence as big as law and bigger. Next, Roscoe Pound, he has propounded the theory of social engineering theory. In this, he has told that how law impacts society is nothing but jurisprudence. Next, we'll see the Hugo Grotius. According to this jurist, he says that law is it is separate from religion. And another jurist, Professor Goodhart, he has told jurisprudence as a ratio decidency, reasonable decision. So it is a conclusion upon the facts of the case. Okay, and the next jurist is Julius Stone. So he has propounded that he has defined jurisprudence as lawyer's extraversion, and Blackstone he has defined jurisprudence as judges don't make law. What they do is they declare what has always been a law. And the next jurist is Alpine. Alpine he has defined jurisprudence as the science of right and wrong. Okay, and Keaton is another jurist, and he has defined jurisprudence as systematic arrangement of general principles of law. Next, jurist is Cicero. Cicero is he has defined jurisprudence as legal knowledge, and it is the natural law and right reason. Next, jurist is Gray. So he has propounded or he has defined jurisprudence as arrangement of a court's rules and principles to so how it is been practically applicable. So how the law, the rules which is made by the court is how it is been practically applicable. That is nothing but jurisprudence graces. And now this was the nature of law. Now let's see the sources of law. So sources of law is of legislation. It consists of legislation, precedents, racial residency, stare decisions, and customs. So first let's see legislation is nothing but it is the will of the state. And precedents is nothing but it is judicial decisions. And ratio the secondary is reasonable decisions. So reason for the decisions. So it is the conclusion of the facts of that case or a particular case. And, stare decision is nothing but it is the bindingness of precedence. So precedence is nothing but which the higher courts the already decided cases are taken in the other case also. So they'll take as reference. Now let's see some case laws regarding this. So case law is that in my house versus Renly, in this case what happened is that Supreme Court under Article 141 of the Constitution. So here the Supreme Court has decided that the decisions binding on the lower courts, it is binding to the lower courts. In similar cases, the decisions are binding of this. And in another case, that is Bangalore Immunity Company Limited versus State of Bihar. So in this case, what happened is that Supreme Court said that precedents should not be followed blindly, but instead law should adapt to the changing needs of the society. Okay, thanks for watching.